Coercive control in the context of Australian family law matters. Let's talk about it. I recently read a really helpful case on this exact topic. It's called Melounis Melounis No 6. So in this video, I'm going to talk about this case. I'm going to show you some examples of behaviour which, when considered in the context of the entire family dynamic and the history of the relationship, the court found that the father had perpetrated coercive and controlling family violence upon the mother. So we'll take a look at some of those behaviours and some of the events that led the court to form that view. And we'll also talk about what is coercive and or controlling behaviour. Melounis and Melounis No 6, 2025. You can view and read the entire judgment for free using Ostley. They do not use the parties' real names, they are pseudonyms. By way of background, there were two children. One child was born in 2013 and the other was born in 2016. So the applicant was a mother. She was 42 years old and she currently resided in suburb BW. She was employed as an administrative assistant. The father was 49 years old. He resides in suburb AV and he is a senior manager. So at the time of this decision, both parents lived in the GC area of Sydney. The litigation saga between the parents commenced in October 2019 at a time when X was 5 years old and Y was 3 years old. For the vast majority of the children's lives, they lived under the shadow of the seemingly intractable conflict of the parents. So there were already final parenting orders in place that provided for the children to live with each parent equally. And prior to the final hearing, there had been 2 interim hearings. The court notes that the father had also filed several contravention applications. All of the contravention applications were unsuccessful. When dealing with matters involving allegations of coercive and or controlling behaviour, it's really important to consider the entire context. So in 2019, the parents attended counselling without success and they had an altercation. And as a result of the altercation, the mother was charged with intentionally or recklessly destroying / damaging property, and a provisional ADVO was taken out against her. Now, a month later, in 2019, there was an altercation between the mother and the paternal grandmother, so the husband's mother. And in response to that, she was charged with common assault and arrested and kept overnight by the police. One of the bail conditions imposed on her was that she was required to live with the maternal grandmother in City AJ. Now, importantly, the charge of common assault and the ADVO related to the paternal grandmother was dismissed in mid-2020. But this involvement with the police is important context. Also, it's important to note that the city the mother wanted to relocate to with the children was City AJ, where she had a lot of support from her maternal family. So her mother lived there, and I believe a sibling or multiple siblings also lived in City AJ. Her brother was offering her a job and income. So there was aspects of financial support and emotional support for the mother in City AJ. Dad wanted the equal time arrangement pursuant to the existing final parenting orders to continue. One of the key issues in this case was whether family violence had been perpetrated by the husband / father to the mother. Paragraph 46, the court explains what coercive behaviour is and what controlling behaviour is. Coercive behaviour, a pattern of acts. Such acts will be characterised by assault, threats, humiliation and intimidation, but are not confined to this and may appear in other guises. The objective of these acts is to harm, punish or frighten the victim. Controlling behaviour, a pattern of acts designed to make a person subordinate and or dependent, achieved by isolating them from support, exploiting their resources and capacities for personal gain, depriving them of their means of independence, resistance and escape, and regulating their everyday activities. Paragraph 49, the court talks about the fact that coercive controlling behaviour, sometimes you can have coercive behaviour or controlling behaviour, or it can be a combination of coercive and controlling behaviour, but it's a very broad definition, and so it's important to consider the fact that you could have coercive and or controlling behaviour. As an expert in this case, it's Dr. C.A., and they said that the least detrimental outcome would be to maintain the existing share care arrangement. However, they said should it be held by the court that the mother has been a victim of ongoing family violence perpetrated by the father as alleged by her, and that her actions have been in the main in response to persistent behaviour perpetrated by the mother, under such circumstances, it would be appropriate for her to relocate to City AJ with sole parental responsibility and for the children to maintain regular weekend and school holiday contact with the father and paternal grandparents. In a single expert report, Dr. CA considered the views of the children and concluded that both children missed their mother and wanted to spend more time with her. They both identified with the mother's position. In particular, they both seemed to understand that the mother intended to move to City AJ regardless of the outcome of the present case. Interestingly, the court declined to place weight on the children's views. It said, the court will place no determinative weight on any views that the children have expressed, whether to their parents or third parties, including Dr. CA. The evidence indicates that the children are caught in the crossfire of intractable conflict of the parents, which has now subsisted for most of their lives. In some respects, the children are resilient. In other respects, including as observed by Dr. CA, they are very much aware of the conflict and caught up with it. Whilst important for the court to have considered the views of the children, in this case, the court declines to place determinative weight on their views. Paragraph 66, Dr. CA was asked questions about the characteristics of successful equal time parenting arrangements, and he talked about for an equal time arrangement to be effective, what you'd be looking for is parental capacity. Can each parent appropriately and adequately parent the children? Respect for the other parent's parenting, involvement in school and extracurricular activities, flexibility, trust, mutual respect, goodwill, and communication to allow problem solving. So that wasn't identified in this particular case with these parents. The mother's unchallenged evidence. So the mother was not cross-examined about her evidence that she gave in her trial affidavit about the impact of the father's behaviour towards her. The mother deposed in her affidavit about the difficulties of co-parenting with the father. The mother contended that communicating with the father caused her to change her behaviour. So his behaviour caused her to change her behaviour. For example, she would have to mentally prepare in advance for any communication with the father, and family occasions would need to be planned well in advance because of the inability of the parents to reach an agreement effectively. In subsequent paragraphs, she deposes to incidents which exemplify some of which are discussed below. So she describes careful structuring of communication with the father in order to achieve a response from him. She describes how this communication takes up a great deal of energy and causes me a great deal of anxiety. She describes the father's communication with her as extremely formal and manipulative. The court found that on many occasions the father's communication with the mother was in fact manipulative. The mother explained her preference for communication via text rather than email because the father uses email as a platform to send lengthy accusatory messages, which the court will find from the extensive email evidence before it is a self-evident characteristic of his email communication. The father's communication style was described by the mother as an example of his ongoing attempt to control and manipulate interactions. She described the sense of anxiety and hypervigilance she experienced because of the father's communication with her. The court will find and did find that her description of the father's communication is correct. The mother described her efforts between 2021 and April 2024 to encourage the father to use our family wizard communication. This saga is further discussed below. We'll get to that issue. So the mother explained in her affidavit that she felt constant feelings of fear and helplessness. She felt her body does not want to work with her, and she says she felt sluggish and tense. She says this is a reaction that I have not only to the legal proceedings more generally, but also to each time that there becomes an issue with the parenting arrangements and communication with Mr. Melounis generally. The mother states that her belief that her legal fees are a direct representation of Mr. Melounis' conduct and financial abuse that he has perpetrated against her. The mother explains that she now experiences constant feelings of fear, helplessness, and distress. The emotional turmoil eventually manifested in physical outcomes. Any legal context triggers a fight or flight response in her body. It causes her insomnia, her heart begins to race, and the feeling of being faint. These experiences have become so ingrained that even anticipation of legal proceedings, police, or judge interactions brings on these physical reactions. The mother explains feeling like she has not been able to fully relax for over 5 years now. And the court says none of the evidence was challenged in cross-examination. And the court has no reason not to believe the evidence of the mother in this regard about the impact of the father's behaviour on her. Cross-examination, Dr. C.A. said that the mother's descriptions were consistent with post-traumatic stress disorder. The court says at 89, it is palpably clear from the mother's evidence that she experienced both physical and emotional response to communicating with the father, which was traumatic. The father's evidence does not suggest any such response. Indeed, the court will find that the totality of the father's evidence suggests that he was the cause of what the mother experienced. Moreover, the mother's evidence describes the financial impact on her of the father's behaviour. Perhaps the clearest example is the unchallenged evidence she gives of the impact of the father's behaviour following the final orders were made in relation to the sale of the home. We'll get to that in a minute. Evidence was that over the last few years, she has felt perpetual feelings of it's always something. The mother deposed that communication is psychologically draining and emotionally triggering. His messages are often either aggressive and accusatory or unnaturally pleasant and performative, particularly in the lead up to court. The court said, except where indicated to the contrary in these reasons, the court finds that the mother's evidence of the impact on her of the father's behaviour goes beyond a statement of mere perception and experience, but because of the form, intensity, and context of the behaviour, it is evidence of impact on her that is objectively appropriate, factual, and a reasonable response to that behaviour. Moreover, to the extent that a pattern is necessary, it will be self-evident from the findings that the court makes below, which we'll get to. The context of each event is either explicitly stated in the reasons or referenced in the trial affidavits. Where the court has made definitional findings about whether the behaviour experienced by the mother is coercive or controlling, it has done so cautiously and with reluctance, noting that the foundational basis of each concept is the exercise of power, and the risk is that existing attempts to define are potentially limiting and inconsistent with statutory intention. Thus, in this context, to seek to categorise or label behaviour is artificial and potentially minimises the experience of the mother in this case as the victim. Even if the court is incorrect in making findings that the behaviour of the father amounted to family violence for the purpose of Section 4AB of our Family Law Act, those same behaviours nonetheless justify, in the view of this court, the orders that are made. So the court is careful there, saying like, even if I'm wrong with describing all of these incidents as coercive controlling behaviour amounting to family violence, even if I'm wrong on that, the behaviour is still sufficient for the court to believe it's in the children's best interest to make orders allowing the mother to relocate with the children. Now we're going to move on to talk about the incidents and the events that constituted coercive and controlling behaviour. We're going to start this section with the Our Family Wizard application saga. The mother contended that she attempted to implement the use of Our Family Wizard since at least 2021 to seek to improve the communication with the father, and that in fact this did not occur until April 2024. The lengthy correspondence between the mother, those who represented her, and the father about this are in evidence. The father gives no evidence about this issue in his trial affidavit. However, he was cross-examined about it. When it was suggested to the father that the mother had communicated anything on specific dates about the use of Our Family Wizard, his most frequent answer was that he did not recall receiving this communication. The court observes that one of the father's most frequent responses to questions was to the effect that he did not recall receiving things the mother sent to him or events occurring as the mother contended. The frequency of such responses leads the court to have serious doubts about the father as a historian of past events, even relatively recent past events. What is curious, however, is the father's capacity to recall communications when it was in his interest to do so. For example, he recalls a text message the mother sent to him on 24 November 2022 regarding school holidays, but curiously, not a letter sent to him about Our Family Wizard on 2 February 2023. The court says that the evidence suggests that on or around 16 October 2023, the mother formed a view that the father had agreed to use Our Family Wizard, and the court agreed with this. But that did not, in fact, occur. It was not until 10 April 2024 that the father agreed to implement Our Family Wizard. Indeed, the father admitted in cross-examination that he regrets not using the app earlier. He accepted that before this time, the mother had been pressing to use it in order to improve communication. Of concern to the court is the father's underlying attitude about using Our Family Wizard. For example, at paragraph 287E of the mother's trial affidavit, she sets out an email from the father on 10 April 2024 in the following terms, and I quote, "Hello, Ms. Melounis. I'm happy to try My Family Wizard app if that will result in you responding to the ongoing outstanding questions such as FaceTime, disclosure of funds, interests, extracurricular activities. As you are aware, harassing me via SMS or phone calls will result in I having blocked you as I have done so since 2018-2019. Therefore, written communication is the only solution to combat harassment. Hopefully the Wizard app has a language filter to address your comments. Cheers, Mr. Melounis," end quote. The court is troubled by this email. The father frames agreement to use Our Family Wizard as conditional on the mother doing something, implying that she was solely responsible for the communication issues. The reference to harassing me strongly suggests to the court underlying hostility as well as externalizing responsibility for communication problems to the mother. It is curious that he would refer to Our Family Wizard language filter, but use unfiltered terms like combat harassment. The email was sent just over a year before he gave evidence to the effect that he regretted not using Our Family Wizard earlier. That insight was clearly not present on the 10th of April 2024. That email bespeaks resentful acceptance of Our Family Wizard and a manipulative attempt to make the mother responsible for its need. This is precisely the type of email that the mother was describing at paragraph 287 of her trial affidavit as superfluous and hurtful. The court accepted what the mother said, which is that sometimes the father's emails and correspondence was really aggressive and rude, and then some was artificially sweet. The court says equally troubling for the court is the mother's evidence that the father sent her a message on 29 Jan 2025, which said, "Additionally, you could reconsider your position on not using the family app you requested. I purchased it and invited you to use it since 2024. The court agrees with the mother's characterization at paragraph 288 of the trial affidavit as a calculated attempt to change the narrative on what had occurred, particularly as we are in court. It is from the court's perspective a distortion or manipulation of the truth, potentially to mislead the court, but also a form of control or attempted control of how the mother communicates with him. This evidence about Our Family Wizard is significant on several levels. The father's resistance to use Our Family Wizard for several years, in a case which he clearly acknowledged that conflict was high and communication and trust was low, demonstrates a deep lack of insight about the need for his children to have parents who can communicate effectively, notwithstanding distrust and high conflict. It reflects very poorly on his capacity to provide for the children's emotional and psychological needs, but instead signals a prioritizing of his own need to control how and when communication takes place. When the mother deposes to the impact of actions of the father, such as in relation to Our Family Wizard, so she was trying to use it and he was saying no and then flipped the script and tried to say, "I wanted to use it, not you." So the court says that it finds these to be reasonable and proportional. Moreover, the court finds, at least in relation to Our Family Wizard issue, that the father was acting intentionally. Next issue, child-wise dance concert. So the mother gives evidence about wanting to take the child to her dance concert so she could get the child ready with costumes, hair, all that stuff. And she describes a lengthy text message exchange with the father, within which she was asking for permission for her to take Y to her dance concert. The father does not refer to this incident in his affidavit. In cross-examination, the father was clearly aware about this. The mother's request came in November 2024, about a month before the event, and such request was for the father to agree to the mother taking Y to the dance concert and to get her ready for same. The father explained properly that he was in agreement with that. Counsel for the mother put it to the father that in order to get agreement, lengthy messages between the parents were exchanged. The mother's message also tried to resolve some uncertainty about the order for the end of year school holidays. The father agreed he received the message. He agreed with the request to prepare Y for the dance concert was not unreasonable. So Dad says, I agree, it wasn't unreasonable for Mum to ask me to take her to the concert. He agreed that the mother's message was polite and was one that was conducive to try to make it best for Y's concert. It is clear the father, however, did not agree to the proposal in relation to the summer school holidays. His message response to the mother is in evidence. Counsel for the mother put it to the father that his response was to engage in what I would call communication warfare. Your responding text does not address the concert at all. Instead, you say you don't agree to the variations. It wasn't a variation that she was seeking. She was trying to be child-focused, wasn't she? That's what the wife or the mother's barrister asked Dad. The father did not agree. He viewed the mother's request for a variation to the orders. He insisted that he agreed the mother could take Y to her hair and makeup, to the concert and do her hair and makeup and costumes. The court pauses at this juncture and finds that in no way can the father's text message be interpreted as agreeing that the mother could do anything in relation to the dance concert. The father eventually conceded this. He also considered that perhaps he had misinterpreted the mother's message as a contention that he could not also attend the concert. The court further finds that it is not reasonably possible to interpret the mother's communication in a way that excluded the father's attendance at the concert. He simply made that assumption. He read what was an innocuously framed child-focused communication through a prism of suspicion and mistrust. There was no conciliatory response from the father. Indeed, his message made clear that he was trying to negotiate a concession for the dance concert in return for an agreement about summer school holidays on his terms. You can see here, what would have been child focused is for the father not to try and get a quid pro and a win on another front. What the court is saying is, the mother, you said it's reasonable. Mum wants to take her to the dance concert. Mum wants to do a costume, get her hair and makeup done. You could have just said yes. Why does it have to be this warfare? So this becomes evidence of coercive and controlling behaviour. You can't just be child-focused and say yes or no. It has to be this battle of, well, yes, if. So then the court says, of separate concern to the court is the following extract from his response to the mother's request. I quote, I will respond to non-urgent matters on weekends on an ongoing basis. If that is not okay, please let me know why. Regarding the parenting app, since I haven't heard back from you, I assume you are not agreeable to using it, noting the mother was the one asking to use the app. I believe it would benefit our co-parenting and I will seek orders for this to be implemented. Additionally, I will seek costs since I shouldn't have to go to court to achieve outcomes we previously agreed upon, end quote. Counsel suggested to the father that he was saying to the mother not to contact him unless it's convenient time for him. Once again, the court notes he was seeking to control when communication took place and thus subordinate the mother in this context. Whilst the father denied the contention, the court finds it is the clear purport of the message and consistent with other evidence before the court. Counsel asked the father whether he considered the dance concert to be a non-urgent matter, a question to which he did not respond. He nonetheless did concede that he didn't respond in a positive manner and I quote, definitely could have done a lot better, end quote. The message refers also to our family wizard, considered by the court above. There is an obvious hypocrisy, the court notes, in the father espousing the potential benefits of co-parenting using our family wizard in circumstances where he did not agree to this until almost 2 years later. The court finds that the father was once again trying to reframe or control the narrative about our family wizard into something which it clearly was not. The final characteristic of the message is, once again, the threat of litigation, including costs. Court says the message about the dance concert continue, albeit in quite frantic terms, from the mother who was clearly and simply trying to establish whether the father agreed about Y's dance concert. The father's messages were unresponsive to the dance concert issue, even though the mother had explained to him that Y was becoming anxious about this. In one message, the mother capitulates to the father's demands about summer school holidays if he would let her take Y to the dance concert. He has successfully subordinated her will. The father was oblivious to Y's mental state, her anxiety about the concert. The father ultimately agreed after 13 days of discussion about the concert and manipulating the communication to pursue his own agenda about the summer school holidays. He eventually conceded, and I quote, "I should have responded earlier regarding Y's concert, absolutely," end quote. Before moving on to another topic, the mother's counsel put to the father that he viewed the dance concert incident through the lens that if it was something important to the mother, he would make her sweat about it. The father denied this. Counsel contended that he was incapable of viewing this as something that was important to child Y. He denied this. The court finds his denials to be disingenuous. When this incident is viewed in the context of the entirety of the evidence before the court, it exemplifies once again the desire to control the mother's behaviour, in brackets, for example, to engage her in a war of communication, attrition, which depletes her time and emotional resources, and then to gain the capitulation the father achieved, in brackets, as well as the singular inability to perceive the episode from the child Y's perspective. This goes beyond a lack of insight. It suggests a significant parenting deficit whose genesis is in the desire to control. This incident demonstrates a complete inability of the father to participate in child-focused parenting. Next incident is titled "The Mother's Cousin's Child's Christening." The mother's trial affidavit, she talks about wanting to take the children to her cousin's daughter's christening in City AJ in October 2022. This would occur in the father's weekend. So she requested a swap of weekends, initially by text message. Both communications are in evidence. The children were to play a special role in the christening ceremony, being candle holders. The father did not respond, and thus the children were not able to attend. In cross-examination, the father stated he simply did not recall this incident, but didn't deny it happened. The court finds it did happen. He does not refer to it in his trial affidavit. He denied receiving the email or text message. He agreed the email was addressed to him at his regular email address. The court does not accept the father's denials. On the facts of this case, the court finds the father to be a poor historian. It is implausible that he received neither an email sent to his email address nor a text message sent to his phone. The curious evolution from the father in cross-examination, not recalling this incident, to a very firm denial about not receiving the communications, adds to the court's skepticism about his evidence. The more likely scenario the court finds, not just on the basis of this incident, but the evidence in its totality, is that the father chose not to respond, not just because he couldn't see the benefit to the children, but because cooperation with the mother was something he sought to avoid. This is consistent with an agenda to coerce or control. This is not just a lack of insight issue, but a fundamental flaw in parenting capacity. Next issue is titled "The Children's First Cousin's Christening." So the mother wanted to take the children to her brother's children's christening. The mother and children ultimately did attend, but the focus is on the journey to reach agreement with the father. The request was first made on 14 June 2023 for the parents to swap weekends they had the children. On 25th of June 2023, the father responded with, in substance, an allegation that the request was a last-minute one. They attended mediation on 20 July 2023. The mother again requested the father reconsider. He responded on 2 August 2023, but in his reply, he also sought to negotiate arrangements for Father's Day and Mother's Day. The father was cross-examined about this issue. He was taken to his email dated 2 August to the mother and the 5 other people at Coleman Gray Lawyers. So he kept copying the mother's lawyers in, even though the mother had said multiple times, "I'm self-representing for parenting, do not copy my lawyers in. They only are handling the financial matter." And he kept copying them into correspondence. In this email, he makes no mention of the upcoming christening, but focused on his demands about Father's Day and Mother's Day. The mother's response to this email occurs just a few minutes later on 2 August. It was an temperate response calling the father a liar, although with the benefit of hindsight, the court understands the mother's frustration. The father responds with an email on 20 August 2022, which in effect, he threatens to write to the court and the police because the mother was threatening to breach court orders by taking the children to the upcoming christening, knowing that no agreement had been reached. He again raised an issue unrelated to the christening. Again, you see here, I don't get my way, I'm going to threaten you with police, noting that that's likely to be a trigger. You have to remember what happened with the earlier on in 2019. The court says it's hard to understand how the father's contention that the mother was threatening to breach orders when it is palpably clear she was trying to seek his agreement to swap weekends. When pressed in cross-examination, the father described the chain of communication as, and I quote, terrible, and agreed that it was, and I quote, appalling behaviour. He agreed that once again he was making threats to go to the police and the court. A quite remarkable thing happened at that point. He was asked whether he recalled sending the email on 20 August 2023. He said he did not recall. When the court intervened, pointing out that he had just agreed that it was appalling behaviour on his part, the father did not have anything further to say in relation to his recollection of sending the email. The court does not accept the father simply does not recall. The father further insisted that there was still no consent for the children to attend the christening. On 23 August 2023, the father's emails to the mother and he carbon copied the 5 other people at the specific law firm handling her financial matter. The court says it is a strange email, completely different to the tone of the 20 August 2023 email. It was almost as if the email had been run through a filter to eliminate some of the toxicity present in the father's other emails. For example, it says, and I quote, "He hopes this message finds everyone in high spirits and excellent health," end quote. The email correspondence again focused on Father's Day and makes no reference whatsoever to the christening, despite the mother informing the father in explicit terms that those lawyers do not represent her in parenting matters. He once again emailed the firm on 27 August. The father was well aware that the mother only retained them in relation to property. Indeed, a letter from the mother's solicitor to the father dated 2 February 2023 also said, and I quote, "I confirm, as has been relayed to you on numerous occasions, that my office has been instructed not to accept correspondence and or service of documents from you in respect to parenting matters," end quote. From the court's perspective, the father was never able to satisfactorily explain why it was necessary for him to copy his correspondence to the mother's lawyers, who he knew were not representing her in relation to parenting issues. This clearly embarrassed and annoyed the mother, as well as likely inconveniencing the recipients of his email. When counsel suggested to him that he did this to niggle at the mother, he disagreed. Nonetheless, in the circumstances of this case, it is more likely than not true. Whether the father intended it or not, or whether he was recklessly indifferent about this or not, it is precisely the type of communication that the mother refers to in her trial affidavit at paragraph 281, when she says that his communications take up a great deal of energy and cause me a great deal of anxiety, and it can be manipulative and to create a narrative against me. The mother complains about the father's actions intimidating and embarrassing her. The unnecessary recipients of the father's email communication were also likely to intimidate and embarrass the mother. The mother was entitled to compartmentalize her legal representation as she did. She was trying to save legal costs. She was entitled to a degree of privacy. At paragraph 320 of her trial affidavit, she explains that the embarrassment was from the father's attempt to rewrite her life and character, and that she was constantly worried that people in her life would turn against her as a result of pressure or false allegations from him. The mother's response led the court to find that this is, once again, an example of the father seeking to coerce her by humiliating and embarrassing her in front of her lawyers and control her by isolating her from her support. So there you go. The court found the fact that he kept copying her lawyers who did not represent her in relation to parenting. He refused to follow her request not to contact them about this matter. They had even said, stop sending us parenting stuff, and he still did it. And the court said, you did that to embarrass her and to humiliate her and to control her by isolating her from her support. And there was a finding there. The next event or issue is titled Google Reviews, the father's 1-star Google review of the mother's treating psychologist. So the mother gave evidence in her affidavit that the husband had left a 1-star Google review against Dr. R using a fake name, which the mother understood to be a reference to the father's favourite horror doll. The mother deposed in her trial affidavit that during treatment sessions in mid-2023, Dr. R told her that he believed it was the father continuing to leave false 1-star reviews every few months or so under different names. The mother then ceased to attend Dr. R and gives 2 reasons. First, financial, and secondly, it's hard to heal when you still experience what is causing the stress and anxiety. The mother deposes that while she felt she would have benefited from ongoing mental health support, what the father did left her with a debilitating fear that he will again intimidate or otherwise interfere with any service provider she sees or use confidential disclosures she makes against her. The court says the following at 125. The mother's evidence alone leads to the court finding that the father's one-star Google review against the mother's treating psychologist, whether it was a single act or multiple acts, was likely a deliberate act, or at least an act done with reckless indifference to its consequences, that sought to control who the mother engaged for therapeutic assistance at a time when it was clearly needed and beneficial to her, and in that way isolate her from this support. The father was successful in this regard. It was also coercive in terms of punishing her for using someone he clearly disliked. The likelihood that this therapy might have enhanced and strengthened the parenting capacity of the mother of his own children does not appear to have crossed his mind. In any event, the father was cross-examined about this incident. He agreed that he left a one-star review on the basis that he was, and I quote, unhappy about the outcome of what happened, end quote. He denied that by leaving the review, it might have caused the mother difficulty with continuing to engage with him. Counsel for the mother reminded the father what he had told Ms. A.H. about Dr. R. The passage that was put to the father is found in the 2020 family report at paragraph 43, and I quote, the father has expressed the belief that the mother has serious mental health issues in regard to her lack of capacity for emotional regulation. He sent her to a clinical psychologist, Dr. R, in April 2019, who found that the mother did not have a problem with anger, nor any underlying or overt mental health issues. The father has expressed disgust at the way Dr. R accepted the mother's narrative, whereas the mother believes that Dr. R rightly assessed the root of her problems to lie in the controlling and manipulative behaviour of the father, end quote. Court says, there is no reason to doubt that this is what the father told Ms. A.H. during the previous proceedings. It becomes clear that the father claims to have initiated the mother's engagement with Dr. R, indeed seemingly felt that he had power to instruct the mother to attend a psychologist, and was, at the very least, unhappy with the outcome. Indeed, he was disgusted. The court expresses serious concern, consistent with that of the mother, that this incident demonstrates the lengths the father will go to when confronted with a narrative or situation that is inconsistent with his view or preference. The seriousness of the evidence about the father's one-star Google review of Dr. R can neither be assessed merely as demonstrative of lack of insight, nor as a further example of the father's acute parenting capacity deficit. It manifests in a pernicious capacity to control both narratives and people. Next issue, the father's interaction with the children's school. The father agreed that he left a one-star review, Google review of the school in the following terms, and I quote, my experience after being involved with the school for 5 years is that the school has deteriorated as a result of key staff leaving. Scratching beneath the surface reveals a principle that is aligned with discrimination and unethical values with no tolerance for diversity. Like most are aware, the school would likely close down over the next few years unless the CK school system addresses their poor decision of appointing Ms. CL, end quote. The genesis of the review is the following event. In cross-examination, the father agreed that a staff member had made a complaint about her interaction with him, following which he was asked to leave the school premises. He agreed that because of his behaviour towards that staff member, she had been left feeling, and I quote, very shaky and tearful, end quote. He was surprised that his behaviour had that impact and thought that it was because he had criticised her. When he was taken to the school's record of the event in question, which referred to him as being, and I quote, quite agitated, in a heightened emotional state, end quote, and recounted that, quote, he stormed in and out of the office area a number of times demanding that the school take action, end quote. He accepted that his behaviour left the school staff and teachers quite shaken. The school made a report to police. The father accused the school principal of making up allegations and lying. On 29 June 2023, the father received a cease and desist letter from the legal counsel of the administration, which operated the school. He acknowledged receiving it. It was read aloud to him in court. and it alleged he demonstrated a concerning pattern of behaviour, persistently and at times publicly accusing the school principal and other staff members of unethical, discriminatory and dishonest behaviours, persistently using tones and language of threatening and intimidating nature against staff, making claims against the school and staff that are vexatious and defamatory in nature, end quote. In cross-examination, the father agreed that he should not have kept emailing the school. This is not an acceptance by the father that the letter accurately portrayed his behaviour in interactions with the school. The court finds that the letter is more likely than not accurate. There is no doubt that the father loves his children and they love him. It is indeed curious and disconcerting that he would manifest such behaviour towards the school they attend. The allegation in the letter to the father above that he was intimidating the teachers and staff of the school is correct. The father's actions would have the effect of intimidating the staff, including teachers. The court recognises at paragraph 320 of the mother's trial affidavit that she deposes to the father, consistently intimidating various people that stood in positions to support her, including the previous psychologist, her lawyers, the school principal, and teachers. So far, the evidence of the one-star reviews of Dr. R and the children's school supports the mother's contention. It is also controlling behaviour. At the risk of repeating itself, the court again finds that this incident demonstrates much more than a lack of insight on the part of the father, but a serious deficit in his parenting capacity and a desire to control. Intimidation is a form of coercion. It seeks to limit the ability of a person to act freely. Specifically, in this case, the freedom to adopt a view, narrative, and position that is inconsistent to that adopted by the father. Whilst the father's intimidation in the context of this incident was directed at school staff, it had the same effect on the mother. Given the mother's experience of the father in the context of both Dr. R and the school, the court finds that the concerns she expressed at paragraph 325 of her trial affidavit, that the father will continue this behaviour, is entirely reasonable and accurate. The court asks itself rhetorically, but transparently, given that the father has shown no insight about his behaviour, how can the court be satisfied that he will not behave in the same manner with his own children, particularly at the developmental stage of growing autonomy? So basically, the father seems to struggle with accepting anyone's views or narrative that are not consistent with his own. What happens when the next issue is titled Ambiguous Orders for the Summer School Holidays? So the parents disagreed in relation to the interpretation of orders in relation to time during those holidays. It was common ground between the parents that the orders for the summer school holidays were ambiguous. The focus, for the present purpose, is how they attempted to resolve this. The father filed an application contravention on 17 March 2023 that included this issue, which was dismissed by the court. The mother's evidence about this commences from paragraph 382 of her trial affidavit. What is clear from the evidence is that there was extensive communication between the parents about providing clarity about when and who the children spend time with during the summer school holidays, all of which was unsuccessful. The father denied in cross-examination that the mother had been proactive in seeking to resolve ambiguity about the orders. There is no doubt in the court's mind, from the totality of the evidence before it, that the mother had consistently been proactive in this regard. One example is the communication between the parents initiated by the mother. On 24 November 2022, it sets out what the court describes as a clear and sensible proposal that would have resolved the ambiguity about the orders. The father then sends a thumbs up message, which the mother has interpreted, which the court says quite reasonably, as a communication of the father's acceptance of the proposal. In cross-examination, the father insisted that he didn't respond with a thumbs up. The court does not accept this denial. For his denial to be true, the thumbs up message must have been fabricated, presumably by the mother. There is no evidence before the court which would lead to the conclusion that the mother would fabricate the thumbs up message. The message appears to have been sent from the father's phone on the date and time indicated. The court already found that the father to be an unreliable historian of past events. The court found that the father prolonged the conflict about this issue. And during cross-examination, it was mentioned that he didn't provide an alternative proposal. In cross-examination, he says, the counsel says, well, you didn't at no point did you put forward an alternate proposal, did you? Father, no. At the time, I just assumed this is typical statements from Ms. Melounis, which should just reflect what the orders were. And I just looked at it briefly and assumed that we were reflecting what our orders were. The court finds this to be a dismissive explanation for not advancing an alternative proposal. His naive, indeed disingenuous contention that the mother should just reflect what the orders were ignores the obvious ambiguity of the orders and all preceding unsuccessful attempts to resolve such ambiguity. The father agreed in cross-examination that it wasn't until 8 weeks later, at the end of the summer school holiday period, 2 days before the children were to return into his care, that he then raised an objection to the mother's proposal. He explained in cross-examination that it was only then that he checked the mother's proposal to ensure it was in line with the orders. He agreed he should have checked earlier. On the mother's proposal, the children would have returned to the father on 3 Feb. The mother contends, and the court accepts, that she texted the father to remind him of this. The father didn't collect the children. Indeed, he didn't collect them until the 24th of February 2023. On reflection, the father clearly miscalculated, because if he had accepted the mother's proposal, he would have enjoyed time with the children before 24th of February 2023. The children missed out on time with the father. The father's application contravention that he filed, saying that the mother had contravened the orders, was dismissed. So the court says that the focus is how the parties attempted to resolve this. That's really important, right? The court says on the evidence, the mother acted appropriately in a problem-solving child-focused manner. By contrast, the father acted obstructively and in a rights-focused and controlling manner. His communication about this issue was neither timely nor focused on resolution. It must be recalled that the mother gave unchallenged evidence that the court accepts about the impact of the father's communication on her. Some of these impacts have already been referred to in the reasons. It is clear from the evidence that she has to change her behaviour because of the father's behaviour when communicating with her. When she asserts, for example, in a trial affidavit that the father's communication style is another example of his ongoing attempts to control and manipulate interactions, the fact that she had to change her behaviour is evidence of that control. The court finds that it is more likely than not, indeed it is comfortably satisfied that, the father intended by his communication to control the mother. Even if that were not the case, the totality of the evidence indicates a reckless indifference on his part about the impact of his communication, both on the mother and the children. The next section is titled CJ Concerts. So basically, the mother gave evidence and said she bought tickets for the children and her to attend a concert. The child was really excited to attend the concert on his birthday. It was his favourite artist. Due to the ambiguity of the parenting orders, the father's view was that the children were in his care. He arrives to school, picks up the children from school early. Mum arrives to pick the kids up, excited to take them to the concert for one of the child's birthday. It was on the child's birthday. Big blow up between mum and dad about this concert. So dad's saying, children are with me, drop the tickets here, I'll take them. Mum saying, please let us go. Let us go to the concert. Mum ends up going to the father's home to see whether he would allow the children to come with her. When child X saw his mother, he runs out to the car. He agreed that the mother asked him to allow Y to also attend the concert, but the father says that Y was sleeping. The father then called the police, explaining that he did this so that they could keep the peace. He denied that he did this to advantage his own case before the court. He agreed that the police came, spoke to child X, and ultimately did not intervene. The father agreed that the police speaking with X would have a negative impact on him. He agreed that he hadn't considered this before ringing the police. Mum and X go to the concert, child Y stays home with the father. The father asserted that his conduct was child-focused, and he disagreed that he was using the police as a weapon. And he also disagreed that he was using the court system as a weapon. The mother wasn't beyond criticism. The court noted that had she not attended the father's home, on one view, the police wouldn't have been called. The court says the reality is that the police should never have been called anyway, and that despite the father's denial, this was yet another example of weaponization of the police by the father. The court explains that the father's communication with the mother demonstrates a propensity to litigate rather than compromise, a propensity to demand concessions but offer no concession, let alone capitulate himself. He manifested no capacity to compromise and no ability to reflect on his own actions and to consider the impact of those on the children. The evidence about this incident and the evidence that precedes this gives the court no confidence that the parents are able to collaboratively make decisions about their children in the future. The evidence leads the court to conclude that the mother has demonstrated her mindfulness and capacity to consider the children's interests in decision making, but the father has not. During cross-examination, so the next section is about the father's unsuccessful applications contravention. In cross-examination, the father agreed that all of his applications for contravention were unsuccessful, but he denied that he was using them as a weapon against the mother. He only agreed after many questions and much pressing from the mother's counsel that even after his applications were dismissed, he continued to threaten the mother with further contravention applications. He conceded that his applications would have a negative impact on the mother. When it was suggested that these applications were inconsistent with co-parenting, he explained, and I quote, "I'm seeking to resolve something through contravention applications," end quote, even though it had a negative impact on the parenting relationship. This gives the court a vivid insight into the father's attitude towards parenting. Litigation was an appropriate process despite its negative impact on the relationship. It was, seemingly, by default, his position whenever he couldn't get his way. It was his way of controlling the mother who clearly lacked the financial resources seemingly available to him. The mother describes the impact of the contravention applications on her and the threats thereof. She describes this as exhausting and anxiety-inducing. She explains how she had to appear in person without legal representation on each appearance relating to the contravention applications, as she could not afford legal representation. She identified 9 separate court events where she did so. The court found that the behaviour of the father coerced and controlled the mother into behaving in a manner different to normal. There is little doubt in the court's mind that the father acted deliberately, but even if he didn't, he acted with reckless indifference to the impact on his own children, let alone the impact on the mother. His behaviour, at the very least, distracted her from and rendered more arduous her core responsibility of parenting the children. The submission on behalf of the mother that the father weaponized these applications has substance and is accepted. The court found that the father brought multiple contravention applications in relation to largely trivial matters, all of which were unsuccessful. But it is not the number or frequency of applications brought, it is the context and impact of an application or applications that determines whether there is a behaviour that coerces or controls. Finally, the cessation of the father's behaviour after the events identified above does not change the character and impact of the behaviour that is found to be coercive or controlling. It is hardly surprising, with respect, that the father's behaviour would improve as the scrutiny of the court increased. The next section is the behaviour of the father in relation to the sale of the family home. Okay, so the final property orders allowed the father to have sole occupancy of the former family home. Mum moved out. Mum also had litigation funding to fund the cost of the legal proceedings. There was interest applicable to the borrowed amounts. So there was orders that Dad had to keep the house in good condition pending the sale, and the property was to be sold within, I think it was 18 or 20 months from the date of the final orders. That didn't happen. The father didn't do all acts and things to cause the property to be sold in accordance with the orders. Mum ended up having to commence enforcement proceedings and progress the sale due to the father's behaviour. Now, also, the father started to demolish parts of the kitchen. He ripped parts of the kitchen out. He removed a really expensive spiral staircase. And when he was questioned about this, he says to the court, well, they were defective works, council needed them removed. The court didn't accept that. The court formed a view that he had engaged a buyer's agent to try and buy the former family home on his behalf, and that he'd actually started to demo parts of the house to reduce the property's value because he wanted it to be a lower value so he could try and buy the house himself. The mother's communication to the father trying to progress the sale was neutral and balanced, and the court takes issue with the content of the father's communication, which was contrived and problematic. For example, on the 14th of June 2022, the father sent the mother a proposed email or a proposed letter, draft letter, to be sent to the real estate agent, and it contained the following paragraphs. So remember, Dad's drafting this and sent this draft to the mother to consider. Can you please ensure your communication regarding all offers to both of us regarding the sale? Mr. Melounis will provide you with a key, though he asked the agent not to provide Ms. Melounis or her associated parties access to the property, as Ms. Melounis has removed her items, therefore has no legitimate purpose attending the property. Ms. Melounis has not attended the property unsupervised since October 2019, unless it was during supervised visits to see children. Ms. Melounis has been charged with DV, resulting in a high level of police involvement and engagement since 2019. with 3 occasions occurring over the past few months, as she has sought to enter the property. If Ms. Melounis or her family are seen attempting to enter the property, the police will be called to ensure a civil outcome. The opening inspection will be cancelled. Mr. Melounis will be present outside the perimeter of the house to call the police on site of Ms. Melounis and or her associated parties and request the agent cancel the opening immediately. The agent is not to disclose non-public openings or information to Ms. Melounis that will increase the likelihood of Ms. Melounis attending the home when Mr. Melounis is not present. The court says in cross-examination about the father's draft letter, he acknowledged that the mother would have been entitled to inspect the property before it went on the market. There was no basis for the father's request to the agent not to allow the mother to access the property. It was an attempt to isolate the mother from the support of the agent in a successful sale of the property. It was also inherently embarrassing. When asked to explain why a real estate agent needed to know that the mother had not attended the property unsupervised since October 2019, he expressed regret in writing, but explained he was trying to provide context about how acrimonious the relationship was. The following exchange occurred. Now, may I put it fairly bluntly to you, the only purpose of that sentence would be to embarrass and humiliate my client, isn't it? And he said yes. The court says at 187, the court finds this is an admission of family violence perpetrated by the father. For the purpose of section 4AB1, it is other behaviour that coerced or controlled the mother or caused her to be fearful. The father's own evidence indicates that his intent was to embarrass and humiliate the mother. Embarrassment and humiliation can have the cumulative effect of undermining the autonomy and self-esteem of the victim, thus making them more submissive and vulnerable. Mother accrued over $200,000 worth of interest owed to the litigation funder due to the delay in selling that property. The court found that the father perpetrated family violence in the form of economic abuse because of the actions and omissions described. The mother was denied financial autonomy as the father made her vulnerable and dependent on his compliance with the court orders. When he failed to do as such, for example, delaying the sale of the home, the mother's legitimate access to the sale proceeds, she was forced to change her behaviour. The mother provides evidence of financial burdens in her affidavit and financial use in the context of legal fees. The next part is titled the email address. I'm just going to summarise this briefly, but basically, the mother told the father that she only engaged a particular law firm in relation to property matters, not parenting as well. Now, the father would continually copy 5 different lawyers from that law firm in relation to parenting communication. And the court said, why are you doing that? Like, clearly you were told not to do that. The mother asked you, the law firm contacted you and said, stop sending us communication about parenting. We're not engaged. And he continued to do it. The mother described feeling consistent intimidation and embarrassment in the context of the father's behaviour and him continually copying them into certain parenting related communications. The court made a finding that him doing that constituted repeated derogatory taunts, which is described part of family violence in our act. It's given as an example of FV. The court said it was a spiteful act that should never have required judicial intervention. The court ended up restraining him from doing it and he still did it. Whether it was intended to have this effect or not, it was an act that would reasonably have the effect of intimidating and disempowering the mother and reminding her of how powerless she is when the father could, with such impunity, disparage those representing the mother. You can see from this case that when you consider each of the little isolated events, it might not scream FV, but when you look at the context of the entire relationship and the impact of these little instances of control by the father over the mother, how when you look at the entire context of the relationship, the court made findings that the father had engaged in coercive and controlling behaviour in various ways. As I said at the beginning of this matter, the court did make findings of fact that the father had perpetrated coercive and controlling family violence against the mother. And the court made orders that permitted the mother to relocate with the children to the suburb where her family were, where she had that family support, and where she had the job prospects working for or with her brother. Finish, I'll say this. In the context of considering allegations of coercive or controlling behaviour, Some features of the evidence will weigh more heavily than others, and evidence which may not be significant in isolation may gain greater relevance when placed in the context of the wider evidential canvas. This video contains a single case summary. It should not be relied on as legal advice. You can read the entire judgment for free using Ostley. I cannot stress enough how important it is to obtain legal representation and legal advice that is tailored to the unique and specific facts of your family and your matter.